it was a voice vote, and I did not participate in the voice vote. But I insisted that I'd be counted as a member of parliament present to constitute the quorum before a decision was taken. Indeed, this decision affirms that position that I took. I find that very refreshing. Soon after that decision, a former Speaker of Parliament called me, and he said, I called you to congratulate you for being bold to take this decision, because that is how the frontiers of the law are expanded. Matters that have never arisen are now in the fore because of the numbers we have in the chambers. So anytime there is disagreement, as I've said already, I will interpret the rules and the law as I understand it. I encourage people who disagree with me to boldly state their position, and if need be, refer to the appropriate body like the Supreme Court. So I'm very glad that indeed that clarity has been given. But I'm not surprised. The text of the Constitution was very clear, and even that Article 1093 was clear that you shall not retain the original vote. Whereas in the case of the Speaker, it said you shall not have either original or casting vote. When it came to the Deputy Speaker, he said you shall not retain the original vote. The natural consequence was that you would have a casting vote. This decision of the Supreme Court appears to affirm that position that was strongly argued. I agreed with, but I just stopped short of making that declaration because I thought if we had to make that declaration, I would have preferred that it would come from the Speaker or the House voting that it should so be. But what the Supreme Court has done, in my view, is to clear the way to remove any ambiguities in that respect.
Our attention has just been drawn to a ruling of the Supreme Court on the matter as to whether a person presiding as Speaker, consistent with Article 102 of the 1992 Constitution, which provides for the quorum, and Article 104, can exercise a vote whilst presiding. Our attention has been drawn to a very disappointing ruling of the Supreme Court of Ghana, which more or less amounts to a judicial interference in time-tested parliamentary practice and established conventions everywhere in the world, in civilized democracies, including the United Kingdom. The presiding officer's vote is discounted. So it's not for nothing that Article 102 provides that a person presiding shall have no original nor casting vote. The Supreme Court, to put it aptly, this ruling is judicial support for e-levy, nothing more. Judicial support for e-levy, for a struggling economy in distress, and judicial support for the restoration of a matter that they have said is constitutional, is repugnant to the provisions of Article 102 and 104. But what can we do? They are clothed with the mandate and authority to interpret the law. This is a travesty. This is a travesty of parliamentary justice and a step in the growth and development of multi-party constitutional democracy built on the spirit and principle of checks and balances. Is it not intriguing for us to hear, whilst we await the full reasoning of the Supreme Court, to hear them that, I'm quoting from one of the justices, that the quorum in Article 102 is not the same thing as a quorum in Article 104. That is the ruling. But we know that for quorum, Article 102 is authoritative on the composition of quorum for Parliament for purpose of conducting business. We cannot see any material difference in the provisions of Article 104. But for their purposes, they have said that interpret 102 differently and separately from Article 104. They ought to know that Article 102, even the side notes, marginal note, says quorum of Parliament. The judiciary of Ghana is also failing Ghana's parliamentary democracy in their inability to appreciate the true meaning of Article 110 of the Constitution, that Parliament shall by standing orders regulate its own proceedings. When we regulate our own proceedings, and today reference is only made to the 1992 Constitution and not to the standing orders of the Parliament of Ghana, and in particular, Standing Order 13. Today, as we speak, the Speaker is indisposed. There is a presiding person in the first Deputy Speaker. So, for your purposes, can you imagine what will happen in Parliament? While the first Deputy is presiding, there is no second Deputy Speaker available who will preside to supervise him voting for our purposes. Repugnant and unreasonable decision. He is presiding. So where he is presiding and the second Deputy Speaker for some purposes is not immediately available in the chamber, he will walk down, vote. At that time, there will be no person presiding over the Parliament of Ghana. This is a judicial support for President Nana Addo Dankwa's e-levy that he is laboring to pass. We remain opposed to it, stitch by stitch, clause by clause, article by article.
Okay. After the Supreme Court ruling, remarks are a free Parliament. Honorable Joe Wise, Deputy Speaker, and the leader of the minority group, Honorable Haruna Idrisu. But you're jumping straight into the second topic. Mankind, the Constitution of the Republic of Ghana, Article 102. The 103, 104, and then we will delve into the standing orders of Parliament. 109, 3. Article 102 of the Constitution, I say, a quorum of Parliament, apart from the person presiding, shall be 1/3 of all members of Parliament. 103, 1, or say, Parliament shall appoint standing committees and other committees as may be necessary for the effective discharge of, 103, no kwade say, and shada and kai papa. Yanko 104, say, 104 will say, except as otherwise provided in the Constitution, matters in Parliament shall be determined by the votes of the majority of members present and voting, with at least half of all the members of Parliament present. 2, the Speaker shall have neither an original nor casting vote. 3, or say, where the votes on any motion are equal, it shall be taken to be lost. We'll go on, but Mamisha seem free sample on the Supreme Court ruling. Off air, na argument, a very heated argument. You if you say Benjamin will be moving forward on parliamentary procedures and the work of Parliament, because Nancy Crime say loan agreement be because of negotiation entity yabo atwegu. Oje ne saying Sam
CJ Supreme Court a year ruling your mode by there. Now omadrimu bringing clarity to a year in your mobi. But a camera is a equal there is no clarity at all. Now one thing is missing, and what is missing in this, of course, ABR Oshe emrana edaho as with the letters of the law, and I say even going to the spirit of the law to make your own interpretation. You should always be guided by common sense in terms of certain decisions. I bet that you be making, because say Oshe this particular ruling here, it defeats common sense and certain practices in Parliament.
I didn't.
And Cynthia make us and say now we can say me say just this week here a loan agreement was shut down.
Yes.
And it was shut down based on the decision of Supreme Court based on Article 102.
Some about.
Based on Article 102.
Some about. Judges no omo dem bra na ye adwuma. What do you know? Who feel say o man fa common sense and can
what I'm saying in say mean unim judgment about some more court unka ho be because
we dey free court.
And I'm asem na make me lay premise be.
Yes.
Ebia you a bear amount to ebia prejudice until unka ho be. But whenever a judgment is being made,
yes,
a declaration is being made,
yes,
obia entitled as a Ghanaian, so obekan was
so feel free.
Wait, and that is why in 2012, in 2016, when Supreme Court judgment near the President Akufo-Addo and the MPP took a position, say they don't agree with the judgment,
yes,
but for the sake of Ghana,
they will accept the
verdict. Will just accept
okay,
it. So which means that they don't agree with it.
Okay.
So for me, I don't agree with the judgment. Supreme Court justices
because
I am thinking say certain commonsensical stuff have been defeated. And why the reason I'm saying that and then they say and on Asha say manifeste our parliament because now parliament are saying say well if the justices have said say quorum is very important and as such the one presiding should be part of the quorum as say Article 102 woho ambiguous but due to their interpretation using Article 130 on Monday invoke more powers to do that. So now we are saying say you a quorum of 275 so now will be some say what is the common sense logic in this?
Quorum here 275.
What I'm saying, didn't understand. I'm saying say if you don't get the quorum of 275 members
present.
Members now you have to abide them. We are not doing any serious business.
Na parliament. Omo ya de no muni quorum aye omutimi here. If there's no quorum you can't do it.
Wait. So we are not doing it. So in terms of that, that has been the effect more again. Say even if say share the ruling now abana. Now the right honorable speaker subsequently now DB but now yenshare than say as papa. Whereby a decision obeteke or parliament say obana a deputy speaker aye contrary obekasa na wama decision as standing. Just because he wanted to build the institution of parliament and also the office of the speaker. So what I say, whereby the speaker will be very powerful and have total control. But today, the decision of the Supreme Court has given exclusive power be to the speaker, whereby the speaker now do not or will not even acknowledge or recognize somebody as deputizing him. Until if I come and a certain decision has been made, me being the speaker clothed with the powers, I can nullify just whatever that you have done because you are seen as a member of parliament. Again, it is giving rise to other members to disregard deputy speakers by calling them or referring to them as baby omufi or omudi omo MP. And they are right to do that because the judgments have come to confirm, say, we are a member of parliament, but not a speaker of parliament.
Okay.
But we are thinking Article 60.
We should know that in Parliament they are standing orders.
I'll come to that. But you will see, when you read Article 60 of the Constitution, it tells you that there will be a vice president. And when the vice president, when the president is not there, the vice president acts instead of the president. Whatever decision the vice president takes, as at that time, because before the assumption of the person acting as the president, and I said the person will swear an oath, which means that the obey be a stance.
Yeah.
So it means, say Obi a deputy speaker, as at that particular time, Nipano ebefa the speakership position, he is deemed as the speaker of the house. And therefore, all other constitutional provisions in there applicable to the speaker is also applicable to the person. It's in Article 102, Article 104, and also, Adebakumpa is simple and say, when you go to Article 110, of the 1992 Constitution, which gives Parliament certain powers to enact Omwankasa Emra, Enuntino, or Moya Omostande orders, and the Supreme Court has said, or must track it down, order 1093 of Parliament, standing order, or must track it down and then declaring it as unconstitutional because it contravenes Article 102 and then 104. No. It is very laughable. The reason they say you have not, or Article 110 has not been amended. Okay, it has not been amended. Yes, and still Parliament draws its powers from there. Whereby on one day, okay,
so then say Article 110 should have been amended and Sana Supreme Court
because today Parliament can decide to say we are using Article 110 to still make other laws.
Let me quote Article 110.
To help this,
one is subject to the provisions of this Constitution. Yes. Parliament may, by standing orders, regulate its own procedure.
Regulate its own procedures. So as I say, and out of their procedures, and no many almost standing orders are where they. For all this right from 1992, you promulgate the Constitution. Up to today.
Yes.
And BBN so Parliament can still base on that since it has not been repealed, and as since it has not been amended, and then make other laws in order to govern on one kasa eye. But if you strike that down, and until now honorable is it Mutala? You understand? They were referring to the Deputy Speaker as MP for Bekwai.
That's what MP for Bekwai.
As MP for Bekwai.
He's both, so there's
no problem. As MP for that. But Ebian Kaniyema, he would have been dignified with the portfolio as being addressed as Mr. Speaker. So because there are certain liberties and certain rights are already. Or enjoy Kofi director of NIP. Do understand? Director of NIP. Certain status has been added to their way. And if today you are being ripped off by virtue of certain declarations or certain
I'm a citizen of Ghana first.
No, forget about that. Everybody
I'm a member of the MPP.
Everybody knows.
Before appointment in the transient.
Kofi, you should not. Men cannot sabotage.
MP first.
Men cannot trust.
MP first.
MP first. Intino, who can say MP first? Who as MP Ninano and enjoy the privileges now he's enjoying as a deputy speaker.
The position doesn't rip him of his representative status.
So Kofi, in plain language, for me, judgment is nothing but complete absurdity.
No.
And then
very clear.
No, complete absurdity. It defeats to me common sense, and then it is going to hamper the work or the activities of Parliament. And it's not
the judgment is complete absurdity.
Do you understand? It defeats common sense.
And
also, hamper Parliament, and then people will be the losers. Not necessarily.
The
NDC.
You see?
Candidly, who share judgment here?
Yeah.
Presidents are set their two way.
Yeah.
How man? I mean, this friction between Parliament and Supreme Court.
There was separation of powers.
Yes.
There was hierarchy of powers. In our constitutional arrangement as a country, fourth Republican era, in 1992 Constitution, a guy there, and 1 year, Juma. It me very disappointed. Sir Honorable Haruna Idrisu, say the judgment amounts to interference of the work of the legislature, parliament. Very disappointing because 1992 Constitution, DC for the power. So far, by provisions a woman's in 92 and no assemble Supreme Court judges and no more interpreting. Na Emrani share anything. Emrani share any say. Say Emra wants some eba babiana say mentimona be bema. Because the Constitution no and supreme no. All other laws, any arrangement is subservient to the Constitution into no. Yeah, interpretation every day Constitution. Now if one church a Constitution, the apex court of the land, the Supreme Court of the land, I friend Supreme Court. Because sana oko US here, all other jurisdictions. Emrasem no him for never emrasem module. Judges. Yentimi fa emrasem emeto say parliament enye den enchechim because enye omodwuma. Yentimi fa emrasem emeto say executive ena enchechim because enye omodwuma. Ye were separate arms of government. Obia won adwuma oye. It is a democracy ho nhyehyeye na ekuduru ba bi amentemra se bibam na eye emra nkyerechire mu a na ye de akoma judge fo no ansa na wonko circuit court mpo no na eye se wa ye judge for so many lawyer for so many years ya training mama on titiye ansa na wonko high court na wa practice as a lawyer for 10 years any experience appeal court 15 years and over supreme court wa bo obra nyina awie emra no wa kyerechire mu e de ya adwuma che ye hyehye nso aye kofa bi free universities ba said the Professor Henrietta Mensah Bonsumo any others on mobile. Now, with the academic perspective, naba judges are rise from magistrate court level, circuit court level, yeah, they almost so bad. And I have practitioners. I almost so no court. I put it to you. I interpret law several times, and you have a cocktail of different legal practitioners. I am rano Oma Dori woman, Omotiasia, and a what's our level, no, interpretation on the two. Supreme Court ruling unanimous. Just a judge ba kokoro ni ho anadwen ye ne say odisenti asem na ekoye no one petitioner no eye adwen. Now the decision was based on the constitution. Na enema amatwetwe yi a mebekom akoma akoyi representation ene dikan. Representation no anything. Yes obi a deputy speaker. Enti or your deputy speaker. Oba preside on behalf of the speaker. Unye speaker. Over constitution na speaker yento abama no. Speaker doesn't represent any constituency. Yeah. Untimi nka say ona bujo wise because say friend is saying be kwai for eto abama no ye kwa yaba na baso say speaker ni ho unsi na mu nti no. The representation was say be kwai for nya through onabujo wise no uyi sa representation in na den every ho.
Okay. But what is speaker yento abama no? Yes.
Speaker representing
speaker representing constituency. Good.
Yes.
The speaker is elected.
If a deputy speaker.
Anything about business of the house. Because speaker has no business.
We should make this point. The speakership position is an elected position.
We are saying the same thing.
We are saying the same thing. But what I want to find out is a member of parliament.
Yes.
Speaker Akunyem, speaker Niho, now or acting as deputy speaker or presider.
Yes.
Or no, how do we strike the balance between he being a member of parliament representing the people of Bekwai and then acting as a speaker?
Difference in say Obia ko gina ho na ye be business on behalf of the people of Ghana.
Yes.
What to abam nti e ba doing business what constituency be do call you have a stake in it. That is the representative.
So you can be a speaker.
Yes, but
and an MP at the same time.
Yes, but about business of the house now. Yeah, and she share a business. I'm a Ghana for sa constituency no and do agina. On 20 mean say business of the house no. Uyi me gina mama be quiet. Me gina mama be quiet for me na Ephraim because say at this stage no speaker say want to do no. We tie ne nachi kakra nti me preside on his behalf. You cannot do that. Untimi yes sir. Oh yes sir. Na ke the representativeness of say nipa no on behalf of the people no. Why is our representation there every ho? Eti Professor H. Prempe the solution biaba. Say free say your deputy speakers are almost preside no. Yem pese business no mbe bi there. Any was say samra no. Na say the speaker constituency bi nyina ho onyina ma constituency bi no. Deputy speakers bi nyina no so no. Yen to aba mo parliament. And I say yen appoint wo na enkoye say ojina ho ma constituency because we yes na ke say what deny constituency na ojina ho ma no they are right to representation in all the businesses in the house. It is that simple. Until that representation is very, very important. After parliamentary sovereignty. Parliamentary sovereignty, no, anything. The question of whether a court could interfere in the operations of parliament, no, sometimes a friend of political doctrine, no. And no interest say emrasemu no, say constitution, no, who say parliament are no more, no. A tia constitution na court intimi mem emechire ebajo CJ watemase
me too.
Yes, parliamentary sovereignty wo ho parliament de omo standing orders omo mra omo de adwuma and all that, but 1992 constitution is a Supreme Court using the constitution have power to declare any act by any arm of government or the agency of government which violates the 1992 constitution as null and void. Longevity is not an excuse. It does not matter. Says Anshishi, yeah, the interpretation, yeah, since Gettysburg time. It doesn't matter say since Kwame Nkrumah time. It doesn't matter say since Busia time. It doesn't matter say for time. The fact is say Sisia no ye dey Kwame ahwehwem hu say eye unconstitutional no enkyere say achenti ana yade ana ye. Utime ye ade bi eye unconstitutional for a long time. E bi obi antwen Supreme Court adwen ensi so mo ye enye constitution. It was say consequently parliamentary standing orders are subservient to the constitution and in any case no arm of government or agency of the state, including parliament, is law unto itself because, without exception, everyone and everything in Ghana is subject to the constitution, the court held. And we are subservient, we are standing order, we are when you running procedures are your parliament and are subservient to the constitution. I said, you're quite master of school near
so then when we say parliament is autonomous, where do we draw that line between legally, the parliamentary standing orders and the constitution?
Legally, you cannot say it's completely autonomous. Oh, you may dear, not a speaker to a standing order near or interpreter, and no, judge be an answer executive in a better say we say. It is only autonomous as far as the proceedings of the House is concerned. But say Emerasem ko badia Emerasem no, say the medical man in my background and introduction. Supreme Court and some so we use constitution almost interpret it. It is autonomous only regarding to parliamentary proceedings. And then a course of parliament. But a bamra semana say adwin what enye bako na say call for interpretation. Supreme Court and a better. Into one you are not legally autonomous. So what I see. Next thing no quorum. I say on the issue of quorum, the apex court was of the view that the 1992 constitution distinguished between a quorum for business of parliament, which is Article 102, and the quorum for decision making, which is Article 104. It held that whereas Article 102 prevented any person presiding, either speaker or deputy speaker, from being part for the business of the House, Article 104 prevented only one person elected as speaker and not the deputies from being part of the quorum.
Okay.
Eti eba quorum na nipa ye yini free man den speaker because only the onya homo bia. So what I say. But eba business of the House they are saying medical association money there. Untimi nyi deputy speakers ni free. Or say as to the non-voting quorum, Article 102 makes it clear that a presiding deputy speaker who is a member of parliament and present shall not be counted in determining the number. However, when it comes to determining the voting quorum, Article 1041, no such restriction or limitation is placed on a presiding member or deputy speaker. The non-inclusion of the phrase, apart from the person presiding in Article 1041, must have been deliberate. To hold otherwise would amount to impugning the wisdom of the framers of the Constitution and supplanting their clear intent. Okay. The court held.
Okay. Only ruling here.
Said the constitution no articles na parliament eje omutumi frem no na court no afa bia na omode chechire mu. So what you say? O ma me kwan meto aso na mako voting. Say emre wo ha. O say on the issue of deputy speaker voting, the court held that there was a clear distinction between a person elected as speaker and a deputy speaker. The court was of the view that per Article 97(1, a speaker cannot be an MP, but a deputy speakers are MPs. So the medical
candidate. But Kofi Mamin Bissau, taking into consideration government business, sir, baby asisi baby abedri, ruling ne judgment the freeway abey, and now the entrenched positions are minority for one more eteki. Enyen sunsanso, parliamentary business, thereby by extension, hamwanga minor mo so as say mo say judgment. Kofi Vusungaza.
Let me who is because Ghana dem run a we are a democracy. And ya say you 3 arms of government. Your executive, your legislature, and your judiciary. And a constitution say Emrasem bi kobana 71 civil. No matter the sector of the government it affects, you the court Supreme Court for interpretation. And a Supreme Court interpretation aba. Aman clearly say you do say a yen say. You do say Article 102 say nature, you do say Article 104 say nature, and yamfenye juma. 80 say your parliamentarians, especially minority, omo aye emranimfo wompa no mo yelo amba inde because omo no wujira homa ya omo hyehye emrama oman. Na so omo de emrane be juma de am hu issues bi a yesebam when it comes to implementing this ruling, because a clear laws, any guidelines, I interpreting the debate. Time a deputy speaker be vote to, time my own vote to, for Mukuruma, who is counted, who is not counted, and all that. A clear, and he say, na kunyafa be any, and a ballot box boot to be any. Obi any, sir, I didn't a no, a legal any because Supreme Court, no, am I a no. Democracy, they see the papa internet and say now who say NDC for
but young kind which here.
No, because just imagine say just imagine say you need another arm of government. Summit once say about obey interpretation. And cause like NDC for MPC that so butu speaker chair if
but utie certain commentaries from the minority side, they feel the composition of the Supreme Court, no, and the akofa we nyina in fact, reading some of the comments from the former president and certain members of parliament, you listen to them. I don't know, so only
recently, Supreme Court ruling by panel no composition or some dissented. It doesn't matter how the committee is constituted. Sometimes you always have some members of the panel dissenting when they see say omone ene. So what you say? Into when you asem we di kan ya are unanimous. And same be on so a utiminya PNDC judges are actually omo be shame as Supreme Court judges up to President Kufuor time to President Kufuor the time no amako unanimous. Asem be ho a etimi koye President Mahama nko time judges na unanimously amako vote for BB. No, I mean, me sure say call reports man example to be brave ho sir.
Na President Mahama how many Supreme Court
so judges
no appoint here join.
Me say me no you say I Supreme Court decisions between 12 President Mahama, EBD president, and up to 2016. Now, you been time, you panel judges na appointed during this time. I'm going unanimous decision.
Final question. I'm call Jerome Ho.
The substance of the matter.
Say MPP more opposition and a ruling way by. Obejene say.
I end the black and white. I do clear. It's the many designer you better think otherwise. That's why you dream say MP say o preside say ultimate to aba. Many sure say opposition or your opposition can be legally. I don't know how that position would have changed. I see. And now you so no ye jimredi ntike no omo nyadwe a
NDC for omo jimredi.
Omo dey say omo only one background.
But CJ
only one background.
Asema Kofi Ken. Unim say a 1992 constitution was promulgated under the NDC.
Yes.
Whereby I will show mu from power. When we call the people assembly money adimpo. Mo manye den manko. Inti na we catch and say ye Jim Randy and so on and so forth. But CJ, the difficulty here ye nya sisia wa haye. Na me catch before say by say when you have a written constitution, they said there 1992 constitution, yeah. First now before a year 1957, whereby we were using a year the common law from a year England, and as a Britain for money there. Probably you will see say enka Parliament exclusive power. You cannot alter a decision and as a law which has been passed Parliament. But quite unfortunately, even a written constitution money had a certain power said the in Article 130 and Article 2 Clause 1 money has given Supreme Court certain power of making interpretations and all that. But as to say the intent behind the interpretation and the making, that is also subject to, and that is where the common sense aspect comes in, because no per emrano including with the power to interpret, or interpret it as to how or no day etiase, and or interpretive it becomes binding. If said there is no review for the decision to be reversed and as a bisa, then it becomes final. And to bisa won't say if indeed this particular issue finality has been brought to it, what the businesses are our Parliament. Yeah. When you look at the judgment, they cited the famous issues of Reakoto, whereby a Papa Otisus is a Greek minister. Ne Papa Money are the chain using the preventive detentive act. On mother chain ne Papa Money and Honke can, whereby a habeas corpus was filed in order for them to produce or more and so on and so forth. But in that, Article 20 of the Constitution, as at that time, prevented the court for making any other a declaration or pronouncement to the release of ASR and Kofona or Mocheno or Mono. But today, that isn't the case now because they are taking a cover from Article 130 and then Article 2, clause 1 of the Constitution. Omudi make it whatever interpretation. What I say, in the interest of Ghana full, say any in the interest of Ghana full, or my day, or my make it. But said they are not making now. Say Parliament power, the Speaker, or more power, Parliament, committee, or a legal committee, they can also decide, say they will use Article 110. In order so more best share a mouthful for, or pass, and so bra, now best tracking it down. They can continue on and on and on and on and on. But said they are making, said you Kofi, it defeats common sense. It is full of absurdity. And Mbwamuankasa, Modi loans beba, ye betray ashwe quorum. We will not compromise.
Well, Kofi feels that effect.
We will not compromise. We will not compromise on it.
There was a parliament. The
effect is here and say today, government is contemplating of shooting down a e-levy, not bringing it back to parliament again. Not bringing it back to parliament again because said I'm okay. Say I catch them that I'm posted. Even now, the numbers you don't have the numbers. Form you don't have the numbers. But this was a time in Kasabi common sense.
It's deliberate.
They don't have it. They don't have the numbers.
No. It's a deliberate. Frustrating.
And you see a
government business.
And you see a that. That be in democracy now. Yeah. Say then consensus. So what I say by consensus. And if say by consensus. Now so Obibana or roll cover for better.
Yeah.
Then the same person is telling you say on an international on a consensual base. Now munya day. Now mun taking decisions. No, you will not do it. Nobody will do that. Until the sad way, so government will contemplate of shooting down the e-levy, not bring it back again. Now, baby, obekwa corporate bill.
Use that.
So, don't talk about we use that now, but use that now.
Let me read this from former President.
I'm just landing on this one.
We are no more to us. Former President John Dramani Mahama, after the Supreme Court ruling, posted on his Facebook page. I say, if deputy speakers, because they are members of parliament, can vote while presiding as speaker, they could as well be able to participate in any debate on the floor.
Certainly.
Over which they are presiding.
Certainly.
This is the absurdity into which the Supreme Court ruling leads us.
Yes, because CJ, that is the absurdity now. Because if you say Nipakono, a former part of quorum, and Article 102, now the person can also have an original and then casting vote. And Nipakono bede, then the person as well can also take part in debate, and that is where the spirit of that provision, and I say article comes to bear, whereby the Speaker of Parliament, when presiding that, the spirit of impartiality. But here's the case: the Supreme Court has taken away, and I say, impartial nature na day. If you whereby you say so, be a deputy speaker na otewa. Say ni pakono be ye adea e be favor ono, and I say the political party. And in the deputy speaker, which the Constitution states clearly say the two deputies, they shouldn't come from one political party. Nim say the second deputy speaker has declared say on a majority, an MPP for a birthday, a Juma. You can as well imagine where the Pakoni positions will be. That is why other people are saying say the speaker should declare the seat of Fomena as vacant because we are identified with the MPP and we'll be doing the bidding of a MPP. Same way as a
your voice notes in Parliament, voice votes in Parliament. Those in favor say aye.
Yes.
Those against say no. In this case, said Deputy Speaker, Honorable Joe Wines team, no put two questions now. I want to make those in favor say aye, no, it should be aye. And I say if he's against, he will say no.
I'm for Kasa, I don't think Kasabi. What prevents him? You see, the Constitution.
We are not like I say. The eyes have it.
But what difference does it make? CJ. Say, menu na ti here Kasa. Ah, you mean saying any kasa nti onte kasa na baby do because o kasa bi. O kasa na se bi ade was once na. Dabi.
Like seriously?
Yes, the fact say me no te ho na this is logic.
No, this
is
not.
O kasa mete. CJ kasa mete. It is a me ensambo na se ye be vote e wo bibi na se mumie no mo ya. Do I have to keep quiet before I can hear you? I mean, I don't get where it is coming from.
We are talking about the exhibition. We are talking about the exhibition of impartial nature. We are talking about the exhibition of impartial nature.
Voting is different from debating. Edu voting and wa voting. Edu time I say ujama ko kasa o makasa. Adentina say u vote ana chinchina say o kasa. It's as if say once you are voting, you have to contribute to debating, but they are two different things. So yeah,
na me hwe betimi abie phone lines.
My last point, me make you on this.
Na for yemfa few calls na yemfa.
Yeah, constitution. Yeah. Any say yenkofa MPs, na me deputy speakers. Say free say sa ehihye ne de confusion ba. Yen sa kirem. Na yen kan say yemfa deputy speakers too no so outside parliament. Na enkoma say o go deny but quite an for me representation because they are decided. It's simple, man. But as far as the arrangement is
deputy
like this,
speakers, they will also denounce the privileges now they are enjoying.
Well,
that's how we preside.
No. But as
of presiding, there is additional responsibility.
Go and see their offices.
It's an additional responsibility.
Okay, so
he's an MP first before
a deputy speaker.
He's an MP first.
So which of the offices does he work from?
He's an MP's first.
MP's office
yes.
Or the deputy speaker's office?
Both.
Because your wife is quite for
CJ.
With their issues.
CJ, you ask yourself, say, Oko wasiho, wasi, but if you are no wasi, ekoko wa. At that moment, I will discharge you with duty to wasi say mobano. Oye ne day. It is that all ye nuku and answer
analogy in your
and answer 0302 211 31701 311 31703. But you wait me afraid. No be can come on. We have just few calls now. Yeah, the senior the tactical board. Yeah, the at 12. So Jerome, I'm about 2 minutes before I hit my phone lines.
CJ,
anyway, can be
no clear woman and say, Siciano said I'm a kind. Simon for your day. Yeah, bread. Kofi okaso tofu because if you are penny position no money ade o use coupon
no oya condition service
or they so what I say because you should be grateful to us so here na create our office
na
when office man no so my create
yes
youth enterprise
they say yes na
nip just the change of name. Just the change of
2014.
Name. But CJ, Mama, come and say.
This is the second time on this show.
Is it bad for us to say you're creating an office? You're creating an office.
It's insignificant.
What is insignificant? What is insignificant? What I'm saying is, CJ, and Timon for your day, Timon for bread, and for bread pounds to the CJ, and no, I'm now, right, say me be do a refino. Look at this noble lady. About very noble, speaks very good English. Amoniade, CJ, okay, 5 CDs. Semanfa mana
more power no be an 5
CDs. Or trek it, and this is the extent to which Nippon can accusam say 7 names say not you. No, you'll be or yet Juma. I'm telling you. Kofi na won Kofi young for appointment do you know say food soldiers bebre wo ha food soldiers na omo twen appointment Kofi that is not the same
mama me kokuba sa me fam first scholar
Kwesi uti me ka o level change levels don't
hello Kwesi
yeah
aha Kwesi we are
yeah
okay
I'm want to say
yeah nyame adom ye ho ya Kwesi enti we first scholar
ai where you me tia be dwafo nya yeah. Okay, the woman is me catch friends me kapa aban sha bi maye wan hwe yi anyoma be se kra enam ye duty no you can make me attest duty bia ye cast bia ba ye huno minua ano de toto Yasana Yanshania, Ansha Yuma, come with Omo Tonka here. May I say, edwuma no be kukra
okay
ko duty na abba no me who be crowd HF born to ase na adwene so
okay me da say kwesi yem fa ni tin Francis wo Kumase Francis wo temi nka
Meto kapa
good Francis yentie o
oh media ne say court kan asama atati yedi so na ma say bisa ene say Ropal na ma share say yem fa nya adwuma ya de aye adwuma enti parliament nso amfa bo ya nya adwuma ene ne ebobra mpatwati mase
matwase Francis matwase
bisa panel na onyima no why
Francis Mdase Francis from Kumasi 0302 211 701 211 and you can join the conversation.
Then this for the biom sore na kufufu so na ema na adwuma na kufufu so na ema adwuma. Mo adwuma a wo Ghana nyina ye na de bae. Be 80%. Youth employment ye na de bae.
And then could be so clear sadly because this is the second time
the basic answer I'm giving him the 1992 constitution which is even establishing the various offices and giving opportunity to us. Okay. It was by NDC.
Neighbors about human so neighbors who did hear na pay ntie o.
Me na FJ oso sin di
enka so nana.
I'm catching my money at Jumana. John Ward, Silman Tina from Yoku. Not Benito. Minia, you will not. Now, the American say, you need to be careful. Let's say, how about Texas and no, Nadama, Nemo Dog. Time, with the efficacy of Monpany, the Ecoson, your petrol issue. Petrol and Sakano, on something so afraid, in the same butcher. Et tu peux tout attendre bas on va tomber kana fo na enti ma no on ya na finance minister so we sa fo mra ho na dia ko so mi e mo de you credit to o mi kana ko da e sa no on te ma tell so ma
na was all asre
o ma ni se abobia o to ya na
na was that's that was all asre
na me can say NDC for Omunya sense na yomo keka no digital center say me ko na adakato na hwe ni ho oh ena nyame adom ona bo yesla ani suade hunu ne president adu so hunu ya hyehyɛ ne aye adwuma yi entabodan
ena ufuru e do akọ
ufuru me ba yes
ena digital center
president Kufuor na the executive instrument NEIP before that yes no ba na mutreni nipa 100 NDC time nyina nipa 100 no ombo mu busian 60 President Kufuor the NEIP no de ba no wa training nipa 120,000 abo mu busian 10,000 I create over 10,000 jobs out of it you start esan be use NEIP they create at least 500,000 jobs in the next 3 years na Ghana Enterprise Agency so another 500,000 aka ho na 3 years yenya 100,000 if you retreat na be afin kwa jobs ya transfer ya kwa kwasisha ide begu form across all the industries me ko NEIP de me dey be create adwuma
Kofi what do you
me dey be create adwuma ma Ghana for Ghana mabunu 150,000 jobs from the service sector from light manufacturing industry and micro factories from artisanal and technical enterprises from agric sector and afi akabako fantastic 5 sectors
I have 2 minutes
150,000 jobs this year
man for 1 minute in ma na afi me for 1 minute sign out
CJ all the one no don read being well you are talking about LI and ebo eye office no ho ban so because okay so you are talking about executive instrument ebo ho ban so which means to say you are try to say yeah the yes buy and there was nothing like that so if you are using logic then you should know said the NDC legally established even a youth employment agency. No, wait. Even the youth employment agency, sort as it, because when it came, there was no instrument, whether EI or LI or nothing like that. Sort as it. But in terms of an act, by making it a public institution, it was NDC under a Honorable Haruna Idrisu. As Minister of Employment in the years I don't know. But Kofi just accepted. Said the concept of NDC has today made you. Said and I will say what do actually. It is the concept of NDC. And then you should give credit. You should give credit where credit is due. You should give credit where credit is due.
Yeah, fancy. Now, me ndama beja for say Sam Jerome, or Regional Communication Officer, Western North NDC ɛna Kofi Ofosu Nkansa nti sisi ano ɛna wo sisi wa abɔkyerɛ etiefo ne ahwefo
National Entrepreneurship and Innovation
Program
ɛna ɔmampanin na nada
because body ni kɛkɛ but ɔyɛ de asi but yɛfi hanom yi ɛnɛ mi fi ha pɛ me kɔmia madamfo Christian Intimensa we free mu and they didn't know what to do tema community 2 Italian flats into Mifiape yeah corner 1 week no yeah the acquisition so into tema yeah bahonum within the chief Jerry Force and my member production team abaso dachi hene obo adwuma pa owura AC or hene and other members of the team na minchia Welbeck Ampedu ne home fa no Welbeck we wish you speedy recovery na me aduma na what you say ne e de Nnawotwe dwumadi e de bebre ma rain free the price for greatness is responsibility yakra
so I should video. Say your thing. You be here what I say. Subscribe, share, like it, and comment. Now videos be brain never grow. So be here for François and show. Open Adom TV, Adom FM. You want the mama?